Hello everybody, I'm Vilija Šunaitė, patent attorney, European patent attorney and a lawyer. I'm also the managing partner of Trinity Eurex, the law firm established in Lithuania, and we also have offices in Latvia and Estonia. We do work a lot with startup companies, and we encourage them to commercialize their ideas. And one of the main aspects in this field is protection of intellectual property. I work in this field for more than 25 years already, therefore I have something to tell you. And I would like to start from the quote of the very famous person. I'm sure that everybody knows it. This is Bill Gates. And he used to say that the IP has the life shelf of banana. That's why you have to invest in it and create every day something new. Then your firm will be interesting for other persons, and you will have the most interesting products that could be the benefit for you. And here is another example how beautiful intellectual property is in the life of the company. Just a year ago, the EPO declared the patent of Moderna invalid. The patent was dedicated for the COVID vaccine, and this is what Moderna was famous for at that time. And just after the news went to the television, appeared on TV, the shares of Moderna fell for more than 2%. That was a really dramatic fall at that time, and here I have an example how it looked like during last 12 months, during last year. So you see that one bad news about your intellectual property can influence the market value of any company very, very much. That's why intellectual property is very important in your activity, and this is the first thing that you have to think while establishing your business and making your idea into reality. IP is the first thing that investors look into when they come and search for a good company to invest. And usually they say that good IP management means good corporate management. If you manage your IP in a good way, this means that the company itself is well managed. And protecting of IP in the very, very early stages, just at the moment it is created, is much easier than at the time when your business is big enough, because then there is a threat that you will not become successful just because you missed something in IP protection. So when the investor comes to the company, usually they have the following questions. What IP do you have? Who is the owner of the rights of the IP? Can this IP be protected? How to protect this IP? And is it expensive to protect it? So be ready to answer these questions, and today we will talk what lies beneath each of this question. Firstly, I would like to start from the list of the objects that can be protected as an IP object. Some of them might appear like new to you. Let's say signature, it also can serve as your IP. And we do have a lot of trademarks that reflects the signature of the founder of the company or the author of the object that was created. Also, social media content, social media hashtags, and to name a few. And also we have this rather traditional IP objects like trademarks, designs, inventions, of course copyright, domain names, and trade secrets and know-how. The idea can also serve as an IP object. However, unfortunately, it cannot be protected as the copyrighted object until the idea is written in some paper. When you put it down properly, then the idea can be protected. The idea itself cannot be protected. And be aware when you go to some investor, when you go to your friends, some other companies, and you talk about your idea, they can take it, and there will be no protection. They can make the same idea into some different product, and it will be okay. So be aware not to spread your ideas until they are properly protected. And here I have the task number 1 for you. Answer the question, what IP do you have in your company? Just write it down. Let's make a short audit. Then we go to the strategy. The strategy is very important, and because it makes your IP to flourish, that makes your IP to give profit to your company. And the first thing about the strategy is to create an IP culture. What does it mean? It means that from the very beginning you have to spread the good word about IP. You have to protect the IP. You have to value the IP yourself, and you have to spread this knowledge among your friends whom you work with, among your employees, or among your founders. If everybody in the company understands the value of IP and tries to protect it, then the company will be okay, and your IP will be protected. If IP is put under the table, most likely you will not succeed with your ideas. Do IP audit. Coming back to the first task, what IP do you have? And this helps you to understand where do you stand and what IP needs to be protected. So that's a third step towards your strategy. Understand what needs to be protected. You don't have to protect everything that you create. Protect just the main or the most important things, like your trademark, like the main trademark. You can have a lot of trademarks, but sometimes it's not worth registering all of them. Maybe it's worth to register just the umbrella trademark. Or if we talk about inventions, maybe it's not worth to patent everything that you create. Just take the most important part out of your invention and have it protected, because patenting is very expensive and sometimes you will not afford it. Understand what to protect, and this is also very important because mostly all IP is protected only where it is registered. If you file trademark in Lithuania, it means that trademark is protected only in Lithuania, and anybody in the United States can file it again. So now at this point you have to tell yourself what are the most important markets for your company, and try to protect your IP in these territories. Align the protection of IP with your business goals, and also try to monetize it, because just having the IP, paying a lot of money for the protection of the objects does not work out. Why IP audit is important? I already told a few words about it, but still we have to understand it more clearly. Firstly, when you make the IP audit, when you answer the question, what IP do I have? When you write it down the list, you understand your status quo, and then you can make a search for the objects. Because if you thought of very nice trademark, it does not mean that it can be registered. Then we go through the various registries and see whether it can be protected in the countries that you selected. And understanding the list of your IP provides a competitive advantage. Then you know why you are better than your competitive, and of course competitive if they do the IP audit of your company. Sometimes it's also possible. They understand where do you stand and how to compete with you. So it makes you well established in the market. IP audit helps you to attract investment. As I told, the first question that the investor has when they come with some money to your company, they will ask you what IP do you have and can you prove that you have it. Then knowing what IP you have and what IP or the third persons you use helps you against copying and against infringement of the third person's rights. And it also reduces costs, because while making the IP audit, maybe you will realize that some trademarks are not used anymore, or they are not important, or this part of the invention is not important in your activity anymore. Then you don't have to protect it, which means that you will pay less for the protection of your IP. Then we have very important question: who is the owner of the of the IP that you have? And here I have to say that intellectual property can be created only by natural persons. This means that the company itself cannot be the author of any trademark, of any invention, of any copyright. It's the natural person, the man or the woman, who stands behind it. And this can be the employee who acts according to the employment contract. This can be a party to a civil contract when you sign the agreement for service provision. And also, some scientific institution can be the co-owner of the IP when you transfer it, whether you know it or you don't know it, and we'll talk about later. It is very important that intellectual property can be transferred only by a written contract. This means that if you're with friends sitting in some room at the university, you made some good product, and it's not that you all are authors of this IP object. But if you want to put that IP into the company that you established altogether, you have to sign a written contract between yourself and the company saying that all rights to the IP are transferred to the company. If there is no written agreement, there is no transfer. And this is sometimes it's a big problem, because even though you are the best friends, sometimes things happen, and you will not be able to force or to ask your previous best mate to sign something for you. And here we have a good example of the Facebook. I'm sure that everybody knows it. It's a very old example, but it's a very expensive one. When the founders of the Facebook, they didn't find the proper agreements, and then they had to pay almost $300 million US dollars to other people to get the rights to them. So this lesson can be very expensive. So be sure that you properly establish who are the authors of the product that you made, and did all persons sign the contract that transfer all IP rights to the company. And here I have a task number 2 for you. You have to, when you have a list of your IP, you have to answer who is the author of your IP, and do you have a written contract to transfer it to the company. Then we go to the trademark. This is my favorite one. And trademarks are everywhere. And this is a nice picture made by AI. When we talk about trademarks, I have to say that registration of the trademarks is mandatory, and only registered trademark is protected. So when you think of any fancy trademark, you have to check it, whether it's available in the territories that you want to have it protected, and then register the trademark. I would also suggest to check for any funds available, because usually there are some support programs that can cover part of your fees, because registration of trademark is also not that cheap. So please sure you register it and check for some funds. Trademarks are protected only for certain goods and services, and we have some niche classification which is used in our profession, and we have 45 classes there, and all goods and services that you can find on earth are there. So if you want to have the trademark, I don't know, let's say the trademark sun for some aerospace activity, or the trademark Barbie for some games activity, you can have it, but you have to classify the services and goods properly according to niche classification. That is why also sometimes we meet similar trademarks for different goods and services, if they are not that famous. I would use the Lithuanian example. We have the trademark Saulutė, which is a cute form of the sun, and we have the butter Saulutė, we have the shopping center Saulutė, and also we have the publisher of the book Saulutė. So they all are in different activities. That's why they can have their trademark in different fields. However, if the trademark is well known, let's take Apple, you will not be able to have Apple not for computers or even not for bags, just because Apple considers this trademark as confusingly similar, and they want to protect their reputation. As I told, trademarks are valid only in the certain territories that you register it. This means that you have to choose the countries where you will be selling your product or providing your services and register the trademark there. The registration of trademark is valid for 10 years, and you can renew it for 10 and again 10 and again 10 years. It's like there's no end term. You just have to pay the fee and the trademark is valid again. And I've searched now the Google, and Google told me that Kantar just did the research again, and they found that Apple trademark is the most valuable trademark in the world. This is different from the last year, because last year it was Amazon, but now it's Apple. So when you think of the trademark, you can think of any word, any name, drawing, letter, number, color, shape of goods, even the sound or the packaging, provided that you can put this object, this sign, into the registry. It can be put on the paper so that anybody can read it and understand what is protected. And they have to be able to distinguish your goods and services from other companies or people's goods and services. And usually we have a lot of good trademarks that are made during those short brainstorming sessions, but good sign made in the brainstorming does not mean necessarily that it's a registrable trademark. So I would strongly suggest you to consult a professional so that they do search it for you and they tell you whether this trademark is available for further registration and use or not. And here I have the examples of different trademarks. And we have the shape, we have color, we have sound, and you know that there are a lot of sounds registered as a trademark. I can tell you only a few, and one of them is like the sound of the Wall Street Stock Exchange, or the opening stock exchange. There's a sound when they mash the gong, and this is the registered trademark of the New York Stock Exchange. Nokia melody for the telephone was also registered as the trademark. And yeah, I can tell you there are a lot of sounds registered, and the only feature that such trademark has to fulfill is that you can, by hearing that sound, you can understand what's behind this trademark, what company is behind the trademark, what product is behind this trademark, and that's how it is made. Also, color is a very interesting thing because it's not very easy to register, because they say that you cannot monopolize colors. But once you have your color used for a long time and the consumer understands that this is your color, then you can register it, and it's necessary to use the pattern of colors to identify clearly which color it is. And well, Milka has the purple color for chocolate, and they made it that close to the consumer that there was a time when children in Austria, they draw cows in purple color just because they were in purple color on their chocolate. So your trademark can be anything. You just have to be sure that it's registerable and that there are no other trademarks in the territory that you want to register your trademark in and registered for the same or similar goods. And for this, I would suggest that you consult the professionals. So, can you register the Apple trademark? We talked about it. Yes, you can register an Apple trademark, you can register the Coca-Cola trademark, you can file it, and usually the patent office will accept it, especially if we talk about small countries like Lithuania. They don't check the prior trademarks. So you can file it, they will register for you, but then Apple will sue you and say that, no, it's my trademark, give it back to me. So think of something new that is very your trademark, that reflects your idea in your business. Then you will be unique, and it will be easy to act in the market. How we can protect trademark? And as I said, that trademark can be protected in those territories that you need to do your activities. And here we have different systems. Sometimes we can use only national trademark registration. Let's say you want to do business only in Lithuania. So it's not worth filing in any other countries, just Lithuania, or Latvia and Estonia, or Georgia, or somewhere else. So you can use national trademark registration and have it registered like one by one. We also have European Union trademark registration, which is valid in all European Union. And they say that if we have new countries, the European Union trademark will expand to the territories of these new countries. Also, however, if some country leaves, then protection is not there, and you have to record your protection there. And we had this situation with UK after Brexit, when after the Brexit, the European Union trademark split it into two parts. One was left for European Union, and another went to the UK registry. But you had to do certain things to have it valid in the territory of UK. And then we have the international trademark, which you may use for other countries than European Union. You can use it for Australia, for United States, for Brazil, for Thailand, and if you need like a broader protection, then international trademark is a very good choice for you. Also, what is important, you have to think of registration of trademark in local characters, and this is this concerns mainly Slavic trademarks, when you have Kirillitsa, or when you have Chinese letters, let's say, or Thai letters, or Japanese characters. So you think of the best option for this country, and think whether you have to have a Latin trademark or the trademark in local characters. And here's a task number 3 for you. So do you have trademarks? Just write them down. Are they registered? You have to check. Who is the owner of those trademarks? Are all of them registered in your company's names? And are the goods and services appropriate This means that you have to think not only of the goods and services that you are interested now, but think for the 5 years perspective. If you're going to expand your business, then the expansion of goods and services may also work. And is the territory of registration sufficient? As I told, if you do business in Lithuania, Lithuania is okay. But if you want to do business in Poland or in United States, then you have to think of registrations in these countries also. Then we jump into the invention. And this probably is the most complex thing for you to think of, but this is also one of the most important. We have two words. We have invention and we have patent. And sometimes people mix them. I just want to make clear that patent is a paper. It's a form of protection for invention. Patent is used to safeguard your invention. When you file the invention, the application for invention with the patent office, and it is registered there, you get the paper which is called patent. Again, invention or patent is valid only in the countries that you indicate in your application or in further documents. And if if you want protection for your invention in Lithuania, you file only in Lithuania. But if you want broader, you have to think of other systems of protection. One of the most important thing with the patents is that you cannot file the invention later in certain countries. Let's say when we have trademark, today you can register in Lithuania, and 2 years after you can register in the United States. And that is more or less okay. However, you cannot do that with an invention, because invention has to be new when it is filed with the patent office. So the day of the filing of your patent application is the day when you have to think big. You have to think, where do you want your protection to be valid? And patent is valid for 20 years only, 20 years, and that's it. In pharma products, we have some extension, but it's not like a usual thing. And it's 20 years, and every year, once you get a patent, you have to pay the annual fee. You have to extend the protection of your patent for protection to be valid. As I told, invention has to be new if you want to have a patent for them. And novelty is being discovered not only for the territory that you want protection. Novelty is a worldwide novelty. This means that even if you want protection just in Lithuania, some article or some, again, patent application filed in Australia will have effect on the novelty of your invention in Lithuania. So one of the most important things that you have to do with your invention is to do search and to find out whether there are any other patents that would involve similar features as your product. Invention to be patentable also need to involve an inventive step. What does it mean? It means that it cannot be very simple. And the person who works in your field, when looking at your product, should have a wow effect. And they said, okay, it's something new. I've never heard about it. I've never seen it, and I think it involves an inventive step. That's the talk you have to have with some other professional in your field. And they have to have industrial applicability, which means that you have to be able to use them in everyday life in your field. They cannot be just on paper, they have to be usable. One of the most important things is that medical activities are excluded from patenting, just because they say that you cannot patent things that can serve for human being health. And software, it's tricky. Usually it cannot be like a software, it cannot be patented in most jurisdictions, but there are certain things, certain workarounds how you can protect your software. And that is why you also have to consult here the patent attorney that would assist you in finding the best way to protect your software if your product is this. Again, there are several ways to protect invention in different countries. We have the national routes, which means that filing one by one in different jurisdictions. Then we have a patent cooperation treaty that allows us to file like many applications in different countries with one application. Similar, and it is valid all around the world. Similar thing is with European Patent Convention. However, this is like a regional protection, and it involves just the European countries, not European Union, but European countries. And then after like 50 years of discussions, just a few years ago, unitary patent came into force. And this is European Union countries, but again, it's not all of them. And let's say Poland and Spain are not in the system so far. But you can use it for other countries of the European Union. And well, once you decide on the scope of your protection in the territory basis, then you have to decide which system would you use, because each of them have their advantages and disadvantages. You just put on the paper pluses and minuses, calculate fees because it's really expensive, and you go with one of these systems. And here I have the top 10 technical fields in European patent applications that was made last year in 2023. We see that, well, I'm not going to comment it, and probably the only field that drops down is pharma. All the other fields are going up, and the number of patents are also going up. So people are trying to protect their inventions because it's something that can bring you money. So when you talk about invention, you have to have a strategy, as I told, what to register, where to register, and you have to do the searches so that make sure that your invention is new. You have to file very early, just at the first stages of your invention. You have to think of filing already. And if you go to investors, if you go to universities, you have to be sure that they have the confidentiality agreements with you, because that disclosure, just a simple talk about your invention, can be against the novelty of your invention. And also, I very much encourage you to enforce your rights. Just if you find somebody using your invention or part of your invention, don't be afraid and send the C&D letter, go to the court and make sure that your invention is properly protected, because otherwise you will lose your advantage in the market. And get money out of it. Sign license agreements, allow others to use your invention for some money in return, because you work hard for your invention and you have to get the refund for it. And here's task number 4. Do you have an invention? Is your invention patentable? Are you sure? Did you make a search? Have you filed an application for patent? Who are the authors of your patent? And is the territory of protection sufficient? Please answer these questions so that you can be sure that your invention is protected properly. Design. It's also a very important part of your business, but it's the least protected in the patent offices. Design is the shape of the whole or part of the object. Just for you to understand, we can have a very beautiful table, and the interior design of this table can be protected as the design. We can have the very nice molding to put on the ceiling or on the wall, it can also be protected as the design. It's the set of lines, contours, colors, shapes, textures, and materials. Again, design is valid only where it is registered, so make sure you put the list of the countries that you want your design to be protected. And design is valid for 5 years from the day it was filed, and then it can be renewed for 5 years, and 5 years, and again 5 years, up to 25 years. When we talk about design, we also have national route, so filing country by country. We have international route, centralized filing for certain countries. And we also have European Union or community design, which is single registration in the European Union countries. Design can be protected if it's new and has individual characters, which means that the designer, the other designer that work in the same field should have, okay, that's new, and it's something different from what I've seen before. And here I have just simple examples. The design, the interface of your app can be protected as a design. However, the shape of Ferrari that you're going to buy after you're going to protect your intellectual property and get a lot of money out of it, it can also be protected as the design or any part of it. We can have a wheel protected as a design. We can have a glass structure, glass appearance protected as a design, and a lot of features of this car can be protected as a separate designs. It is important that design can be also protected as the copyright, which we will talk later on. So task number 5, do you have a design? Who are the authors of this design? Is your design registered? And is the territory of protection sufficient? Please check this so you make sure that your design is properly protected. And here we come to the copyright. This is the object, like one of those mostly known objects of IP that does not need registration. Once you made it, once you put it on the paper, once you put it in your computer, the protection starts. You don't have to do anything. Later on, you will have to prove that at that day, at that moment, you have this copyright made by you or by your colleagues, by your friends. So no registration is necessary. Copyright is valid worldwide. So your product can, as a copyright, can be protected in the same way in Lithuania and in the United States. Of course, according to the laws of the United States. But it has protection in every country. Copyright protection is valid for 70 years after the death of the author, which means that when you die, your children or grandchildren can benefit of it 70 years after. And the author, as we talked at the very beginning, can be only a natural person. Also, it is very important again, are the rights transferred correctly, which means that any rights to the copyright, to the object that you made, have to be transferred in a written way. Another very important question that you have to ask yourself is, do I infringe rights of others? Because in the process that you make your own IP, certainly you use the IP of the third persons. I know licenses of the Microsoft, some design programs. Sometimes you sneak into the patent database and see what's there. So make sure that while you make your own product, you do not infringe the rights of the other persons or the third persons. Because in this case, the protection of your object will not be valid. So can you use the part of another code while making your own code? No, or you have to ask the permission of the author or the rights holder. Also, it's people use the open source codes, but in this case it's very important to check the terms and conditions, because sometimes you may find that the clause that states that if you use you are welcome to use the code, open source code, but this means that your product will also be open for all the others. So before you start using some part of the open source code, make sure that you will not fall into that trap. Task number 6. Who is the author of the IP? Do you have a transfer agreement? And is it properly described? I mean, if you take the paper, if you take some record, if you take some code, can you understand what's in there and prove that this is the full object that was made and transferred to the company? Here we come to the trade secret. Trade secret is also one more important thing in the IP, and sometimes you don't want your IP to be public. Meanwhile, while you register your trademark, while you register your design, even the invention becomes open for public within a certain time. So, which means that anybody can access it, anybody can see it and use it for their own purposes. But sometimes you don't need it and you don't want it. And let's say Coca-Cola. If Coca-Cola would have registered their formula long time ago, just when they started, then this drink would be available for everybody already now, and there will be no market upside for Coca-Cola. They will not benefit from this formula anymore. That's why they decided not to register it as the invention, not to have a patent on it, not to disclose it in any other way, just to keep in a secret box. And rumors say that only 2 persons know this recipe of Coca-Cola, and each of them knows different parts of it. I'm not sure whether it's true. I've been to the Coca-Cola Museum in Atlanta. I've seen that safe where they say this recipe is put, but still it's confidential. And that is why Coca-Cola can benefit out of this IP very much now. We have the same with Listerine formula. We have the same thing with the Kodak powder, and KFC seasoning is also part of the trade secret. So if you want to have a trade secret, it has to be non-public information. You have to keep it confidential. It has to be the protected information. It means that there are certain rules saying that this information is confidential, and I order, as a CEO of the company, everybody not to disclose it. And this information has to have the actual or potential value, so that you can make some money out of it. And here I have a few examples of what information can be considered as being trade secret. We have production methods, recipes, algorithms, some material ingredients, principles of operation, marketing plans, customer lists, business partners, chemical formulas. That a lot of things can be protected as a trade secret. And as I said, the only concern is that you do not put them publicly yourself. Task number 7. So do you have trade secrets? Make the list of them. Who has access to it? And are there any proper paper documents that say that this is the trade secret and there is an order in the company that nobody can use it outside? And one more thing that we need to talk about today, as you are part of the university, is your relationship with universities. Because the university is the ideal startup platform, and you can benefit for being part of this community very much. They make studies, they teach you, they provide you the network, they provide you with the resources so that you can make your own IP and create your own products. However, for being that friendly to you, they also want some part of your IP rights. And sometimes you don't even understand that, and it's not bad. I mean, if you get something, you have to give it back, but you have to understand that when you make intellectual property in the university, you are not the sole owner of these rights. And you have to talk to university about the complexity of this relationship. And this is very important to the investor, because as we talked in the beginning, when the investor comes to your company and asks what IP do you have and who owns the rights to this IP, they have to know that university is in this pool, and they will have to share part of this rights with the university. So once you have your product, I would suggest, or before you have your product, I would suggest that you come to the university and you negotiate and clearly understand what rights do you have. Because if university stays in the pool, you will have to align strategy decisions with the university. Let's say university can say, we don't want to patent this invention. Meanwhile, you think that it's very important to patent it, but you will not be able to make it because you share the rights with the university. Then sharing patenting expenses. Sometimes university has some funds, but sometimes they don't, which means that you may fund it yourself, but still you will share the rights with the universities. Who is the owner of the patent? Is it only you, your company, or is it also the name of the university in the column that says the owner of the patent or invention? Sometimes universities want to have some license fee for using their rights, so you also have to negotiate this. So it's not bad. It's just you have to understand where you stand and talk to university about the rights that you're gonna have after you want to spin off from the university. Another very important thing is the publications. As we talked previously, invention is not new anymore if it is disclosed publicly. Sometimes universities can ask you to publish your articles about the product that you're making, and then this means that novelty is away here. So be very careful about publishing information about the products that you make in the papers of universities, and also you have the right to negotiate here. Sometimes you need data from the hospitals, especially if you do some medical researches. You cannot have data on some human beings not addressing the hospitals. Then also there are certain things that you need to consider. First of all, this is a data protection, because any data about the patient in the hospital is GDPR protected. So make sure you have a proper agreements there. And also check the agreement with the hospital that you sign. Are any rights transferred to the hospital to the final product that you make with the data that you get from the hospital? Who or what institutions will be the owners of the product or the patent? Also patenting expenses, licensee. So these are the same things that you have to consider with the university. The same goes to the hospital. Make sure, just one thing that I'm asking you to understand what you are signing and consent to it. Or if you don't consent to it, negotiate and reach your target there. We cannot have IP now without the protection of AI, because artificial intelligence is a big boom now, And I'm sure that everybody uses some AI tools, whether it's like an open thing like ChatGPT or some other more complex tools that are made specifically for your area. It is very important to protect the data that you put in those all AI tools. What I mean here is that ChatGPT can draft you a beautiful claims for your patent application. However, this data stays in this cloud of ChatGPT, and if there is a chance, somebody may try to prove that even before filing the application, you have this data about your invention put in the open tool like ChatGPT, and that will ruin your invention. And this goes also to any secrets that you have. I know any agreement that you sign with the investor. If you put some sensitive data into AI tools, you have to be aware that it may become public. So be aware what you put into those tools. Also, it's very there's like still a question: who is the author of the IP that is created using AI? And we have a few decisions already saying that AI cannot be the author of IP. It's only the human being that stands behind it. So I would love that this thesis goes further, and we will not have a different court practice, but still it is not well established, so we have to follow it. Also, respect the rights of the others. As I told, when you use something, for making your own product, you have to understand which rights do you use. And if you get something out of the AI tool, some information, some article, be sure that you indicate that this is the author and the rights to this product belongs to somebody else, because they also want some respect. And the last thing about AI is to comply with the regulations. Now we have the EU AI Act. It's not an easy reading to understand, but if you fall under the scope of this act, you have to know what to do. And the last thing, this is a nice IP guide for startups. You will find everything that I told you today, and even more. You can scan and download it, use it in your activities, and if you have any questions, please let me know, and I will be more than happy to discuss certain things with you. So thank you for this nice hour, and I wish you the best luck in your studies.